You know, when you live in a planned community, there's always this balancing act between your own personal needs and the rules that are made for everybody. But what happens when one of those rules, one designed for thousands of people, directly impacts the health and well-being of just one resident? Well, we're about to break down a legal battle that started with a pretty simple request. Hey, can you turn up the heat in the pool? And ended up in a formal court ruling.
And at the absolute center of this whole story is Kristeen Herron. For her, you see, the community lap pool wasn't some luxury, wasn't just a place to relax. It was essential. It was her physical therapy. As she explained it, if that water dipped below a certain temperature, it wasn't just a little chilly, it was genuinely painful, and it made her therapy totally impossible. So right away, you can see the stakes here couldn't be more personal.
So how in the world does a community pool become the flashpoint for a legal fight? Let's set the scene and take a look at the exact moment this all kicked off. Okay, so we're in Arizona in a big community called the Villages at Rancho El Dorado. And what's really important to grasp here is the scale. We're not talking about a little cul-de-sac. This place has almost 2,000 homes. And when you're managing shared stuff like a lap pool for that many people, you've got to have some pretty strict rules. And Miss Herron, she's what they call a snowbird. She specifically comes down to Arizona for the warmer weather during the winter months. And that little detail is going to be pretty important in a minute.
So here's how it all went down. On April 15th, the HOA does what it does every year. It turns off the pool heater for the season. For Miss Herron, this immediately makes her therapy impossible. So the very next day, she reaches out to management. But a few days later, the response from the board president is, well, it's firm. They were just following the rules, period. No exceptions.
And this is the point where a personal health issue really blows up into a formal dispute. It's now a group of residents, led by Miss Herron, going up against the governing body of their own community.
And this slide just lays out the disagreement perfectly. On the left, you've got what the residents wanted. Keep the pool at a minimum of 84 degrees all year long. Simple. But on the right, you see the existing rule, which says the pool is only heated in the winter, and only to a range of 78 to 82 degrees. We're talking two completely different ideas of how that pool should be run.
Now, this wasn't just one person's complaint, not by a long shot. Miss Herron got organized. She went out and gathered 112 signatures from her neighbors on a petition to get that rule changed. And on May 17th, she walked into the board meeting and presented it, turning her personal problem into a formal community request.
But even with 112 signatures, the board didn't budge. They denied the request. Their reasoning? They had to uphold the rules as they were written in the community's governing documents, the CC&Rs, the covenants, conditions, and restrictions. That's basically the legal constitution for the whole neighborhood. So, with that door slammed shut, Miss Herron took the next logical step. She filed a formal dispute with the Arizona Department of Real Estate, which is the state agency that handles these kinds of HOA conflicts.
So now, the issue is officially out of the HOA board's hands. It's headed to a formal hearing. And that means both sides are going to have to present evidence, give testimony under oath, all in front of an administrative law judge who's going to make the final call.
And here's what's so fascinating. Get this, both sides, both of them, built their entire case around the exact same section of the HOA rulebook, Article 4.4. Ms. Herron's side said the rule was discriminatory, which that article forbids, and the HOA argued that the very same article gave them the clear authority to make these kinds of rules in the first place.
Then, during the hearing, Ms. Herron's witness, Karen Ellis, drops what seems like a total bombshell. See, the HOA's rules said its temperatures were based on recommendations from the Arizona Department of Health. But Ms. Ellis testified that she called them, and they told her they don't make any recommendations like that at all. This was a huge deal because it basically called the entire foundation for the HOA's rule into question.
But then, the HOA's lawyer pivots. During the cross-examination, they ask Mrs. Herron this really critical question. They try to reframe her medical need as a personal preference. And in a courtroom, that is a massive distinction.
And then came the moment that might have sealed the deal. Under oath, Ms. Herron was asked if her need for warmer water was in fact a matter of personal preference. And her answer was just one word: I agree. It was a huge concession.
So after all the testimony was heard, all the evidence was presented, Administrative Law Judge Jenna Clark was ready to make her call.
But hold on. Before we get to the verdict, we have to talk about this super important legal idea called the burden of proof. See, it wasn't enough for Ms. Herron to just say the HOA was wrong. The law put the burden on her to prove it. She had to show with solid evidence that her claim was more likely true than not. It's a high bar to clear.
And on October 16, 2023, the decision came in. The judge dismissed the petition. The ruling was entirely in favor of the Homeowners Association. So why? Well, the judge's logic was laid out very clearly. First, Ms. Herron just didn't meet that burden of proof we talked about. There was no evidence the HOA even broke its own 78 to 82-degree rule. And then, the knockout blow. The judge made that legal distinction between a need and a preference official, ruling that wanting a warmer pool because it's outside of her preference does not amount to age-based discrimination.
So a dispute over one pool heater in Arizona. What's the big deal? Well, let's zoom out for a second and look at the bigger picture this case paints about life in a planned community.
Really, this case is the perfect example of that constant tug of war inside any HOA. You've got the very real, medically justified needs of one person, and you have to balance that against the rules that were created for the stability and governance of a community with thousands of other people. It's a tough balance. This is also a huge reminder that those HOA documents, the CC&Rs, they are not just guidelines. They are a legally binding contract that you sign when you buy your home. And as this case shows, that contract gives a ton of real, enforceable authority to the HOA board.
And in the end, this whole story leaves us with a really tricky question, doesn't it? In a community that has to live by a set of shared rules, how do we, and how did the courts, actually draw that line between what someone genuinely needs and what's just a personal preference? That's a question thousands of communities are trying to answer every single day.